Hi, this is Professor Moore, and this is a video that is going to give you a little bit of background before you read the case that I have assigned for the mock civil procedure class at St. Thomas University School of Law, which is currently scheduled to occur on Thursday, August 7th at 9:45. So on the screen I have the case as it appeared in the West Publishing System online. And I'm just going to explain kind of the beginning of the case and what it's important to look for when reading a civil procedure case. I am assuming in my presentation that this is the first legal opinion that you've ever read in your life. So that's kind of the level that I'm coming from. If you're more familiar with the background of these things, you may not need to listen to this video. I'm not going to walk you through the opinion. I'm not going to explain the court's reasoning or anything like that, because that's what I want you to read and figure out on your own. But let me start by pointing out some signposts that hopefully will help you. Okay, so the beginning of a case is going to have what's called the caption, and that's going to identify the parties to the case and where the case is pending, what court it's in, and it will give you, of course, the docket number of the case. So we see right up front that we are in the United States District Court. So what does that tell us? Well, United States tells us that this is a federal court. In your introductory materials for civil procedure in the first chapter of the case book, and I believe in your introductory materials for legal writing, it is explained that there are two main types of courts in the United States. One is the federal system, and the other is the state system, with each of the 50 states having their own court system. So when you see the words United States preceding the name of a court, you know that it is a federal court rather than a state court. In a procedure case, what that signifies to you is that the federal rules of civil procedure will apply to procedural issues that occur at the trial court level. The next word, district, in the federal system refers to the level of the court. Also in your introductory materials for civil procedure and for legal writing, it is explained that each court system has a number of levels, and the bottom level, where a plaintiff would go to actually begin a civil lawsuit by filing a complaint, is called the trial court level. And the trial court level has different names depending on what court system you're in. So in the federal court system, the trial court level is called the district court. So you'll see that we are in the trial court level of the federal system. So the next line says that this is in the Western District of Tennessee. And again, as your introductory materials in civil procedure explain, the United States district courts are geographically dispersed all over the country, and this particular district where the court writing the opinion is located is in the Western District of Tennessee. Some of the districts are further subdivided into what are called divisions. So this court is in the Western Division of the Western District of Tennessee in the federal court system. So the next piece of information that you'll see are the identities of the parties to this lawsuit. We have a plaintiff, and it's important to notice that we have two defendants here. We have the first defendant is Shelby County Government, which is probably not the right term, but that's the term that the plaintiff put down, and Floyd Bonner, an individual who, it is not explained in the opinion who Floyd Bonner is, but one can assume that Mr. Bonner works for the Shelby County government. So there's two defendants, and you need to notice the different defendants and sometimes the different plaintiffs and ask yourself, which of these defendants does this particular opinion address? Because the opinion may not address all of the defendants, and that might be an important thing to know. This is just the docket number that is assigned to a case when it is filed in federal district court. The beginning two numbers, 13, mean that this case was filed in 2013. And this date, June 11th, 2014, is when this judge finished and signed this particular opinion that we are reading. Then we see the attorneys for the parties are identified in case there would be some reason you would want to know that. And in the district court, sometimes they have a little summary title of their order, like order denying plaintiff's motion for extension of time to perfect service, which gives you a brief synopsis of where the court is going on this motion. You won't see a title like this on an appellate court opinion. And here is the name of the judge that wrote this opinion, S. Thomas Anderson, who is, as we said, a district judge or a trial judge in the federal system. Moving right along to the first sentence of the opinion, this identifies what motion the judge is addressing in this opinion. So particularly if an opinion comes out of the trial court level, there's going to be some motion that one of the parties has filed, and the judge is going to be ruling on it. So a motion is simply a request to the judge to do something. Please order the defendant to do this. Please stop the plaintiff from doing that. Something like that. So here the plaintiff has filed a motion to extend this time for service of process on the defendant, Shelby County. Sometimes you need to search further in the opinion to figure out exactly what motion is in front of the judge to be decided, particularly in an appellate opinion. But probably in a lot of civil procedure cases, the kernel of what is being decided is going to be contained in a motion that you need to be sure you understand. This is the motion that's being decided, or you'll be a little bit lost. The next sentence refers to the institution of a United States Magistrate Judge. And the magistrate judges are federal judges, but they are appointed for 8-year terms. And they're not judges whose existence is authorized under Article 3 of the United States Constitution. Federal judges who are authorized under Article 3 of the U.S. Constitution are appointed by the President of the United States and confirmed by the Senate. And they have lifetime appointments where they cannot be removed except for bad behavior. Magistrate judges don't quite rise to that level. They are not authorized, unless the parties consent, to decide anything that would be dispositive of the case. So anything that would completely dismiss out a defendant, or anything that would completely dismiss the complaint, or something that would, something where the case isn't going to continue onward. The United States Magistrate Judge is not authorized to decide that. Only the district judge can decide that. Again, unless the parties consent. So the magistrate judge can decide sort of interim problems like disputes over discovery and the like. The next thing to notice here is the causes of action that the plaintiff is asserting against these defendants. That is identified here in the highlighted sentence. Plaintiff is asserting hostile work environment and retaliation under Title VII of the Civil Rights Act of 1964 and the Tennessee Human Rights Act. So this opinion doesn't give us any other facts than that, but what likely is being alleged is that the employer, who seems to be Shelby County, is creating or has allowed a hostile work environment for the plaintiff to be created and has failed to correct that hostile work environment. And when the plaintiff has complained about the hostile work environment, the defendant retaliated against her in some way, like firing her or demoting her or making her working conditions worse. So that's probably roughly what the plaintiff is complaining about. The Title VII is a federal statute, and the Tennessee Human Rights Act is, of course, a Tennessee statute. So one of these claims is a federal claim, and one of these claims is a state claim. And at this point in your career, it's totally understandable if you can't distinguish those two things, but as the year goes forward, it's going to be important to identify what are federal claims and what are state claims for a whole host of reasons that are that become relevant in civil procedure. The point here is that you need to be cognizant of the legal theories that the plaintiff is asserting and ask yourself, how does the opinion that I'm reading affect each of these claims? Okay, so this motion is a motion for extension of time for the plaintiff to serve process on the county. And what does that mean, serving process? You've probably heard something to that effect just in TV shows or movies. Process in a civil case is simply a copy of the complaint, the initial pleading where the plaintiff explains, here's what I'm upset about, and in addition to the complaint, the summons. So this case that we're reading talks about the summons, and the summons is sort of the official document that informs the defendant that you are required to appear before the court and answer the claims that have been made against you. And if you fail to respond, judgment by default will be entered against you for the relief demanded in the complaint. So it's telling the defendant it is not optional to respond to this lawsuit. You must respond to the lawsuit, or you're going to be defaulted. And then the back of the summons is where the process server fills out who they left the summons with and what date that occurred on, so that it can be determined whether service was appropriate on the particular individual that was served. Now, I mentioned that because we are in the United States District Court, that's a federal court, and we are in the trial court, therefore the federal rules of civil procedure govern the procedural doings of the case. So that's why the judge is looking to the Federal Rule 4 in order to see when a summons has to be served and how a summons has to be served. And Rule 4 is an extremely long rule. as you can see, with many, many different subparts. And back in subpart 4C, that's where it says a summons must be served with a copy of the complaint. The plaintiff is responsible for having the summons and complaint served within the time allowed by Rule 4M. So Rule 4M is the provision that is discussed at length in the case, and I've reproduced in a footnote the correct version of Rule 4M. The court refers to a slightly out-of-date version, but I don't think the substance is any different. So there's 4M, and then between those sections are a lot of subsections that talk about how technically you effectuate service of process on particular types of defendants. So here in 4E, serving an individual, that means a natural person like you or me. That's how do you serve process there. Or here's serving an individual if they're in a foreign country. There's a number of means that you can do that. Serving a person who's a minor or an incompetent, a different procedure needs to be followed. Serving a corporation, partnership, or association, so some kind of private business. Serving the United States, that goes on. Here is finally what we get to that's involved in this case, 4J, serving a foreign state or local government, and in particular the defendant here is a local government, so it's subject to 4J2. So it says a state, municipal corporation, or any other state-created governmental organization must be served by A, delivering a copy of the summons and the complaint to its chief executive officer, which in this case would be apparently the mayor of Shelby County, or serving a copy of the summons and the complaint in the manner prescribed by that state's law for serving a summons or like process on such a defendant. So here we're in Tennessee. This is a local government in Tennessee, and so the federal rules of civil procedure for J2 actually incorporate the manner in which Tennessee state law allows this type of defendant to be served. So we don't just immediately say, oh, well, this court is in Tennessee, and so, you know, any way that Tennessee allows is okay. The reason that that is true is because the federal rules of civil procedure say so. Okay, so I hope that that gives you enough background information for you to get going. If there are terms that you don't understand, which I'm sure there will be many, please look them up in a legal dictionary. The sooner you start learning the vocabulary of law, the faster you will be able to read cases and the greater your understanding will be. So as with learning any language, it's kind of, you know, a matter of repetition. And I would suggest also, since this case involves different dates and the time when things happened is very important in this case, that you sit down and develop a chronology of events. So the first date that would be relevant here would be the date that the plaintiff filed the complaint, which was October 30th, 2013. And then you would go about looking for other important dates in the opinion and putting them in chronological order. So good luck, and I will see you on August 7th. Thank you.